I think we can go ahead and get started. Welcome, everyone. Thank you so much for joining us today for Hot Topics in Asylum Law. And we have a wonderful panel today. We have Margaret Kuehne Taylor, excuse me, and Amelia McGowan and Ambreen Walji. And Margaret Kuehne Taylor is passionate about immigration law. She recently retired from her position of Senior Litigation Counsel at the U.S. Department of Justice Office of Immigration Litigation, or OIL, where she litigated a wide range of immigration-related issues in every federal court of appeals that considers such issues. Ms. Taylor currently serves as an adjunct professor at the University of Maryland, Carey School of Law. She teaches an asylum law seminar, and Ms. Taylor is a member of the American Bar Association's Presidential Commission on Immigration and of the editorial board of the American Immigration Lawyers Association Journal. She frequently speaks about immigration issues at bar and community meetings and publishes in law journals. Ms. Taylor is fluent in English, Spanish, and German. And Amelia S. McGowan is an assistant professor and immigration clinic director at the University of Arkansas School of Law. Her scholarship, teaching, and advocacy all focus on asylum law, particularly in the inter-American context, and she has lectured on asylum law topics throughout the U.S. and with universities in Argentina and Costa Rica. Since 2021, Ms. McGowan has served in various capacities on the American Bar Association's Commission on Immigration, where she is currently an advisory committee member and International Law Section Liaison. And last but not least, Ambreen Walji is a bilingual attorney and social worker with over 5 years of extensive experience in immigration and family law. She currently serves as the managing attorney for the Pro Bono program at the American Bar Association Immigration Justice Project in San Diego, California. In this role, Ambreen leads efforts to recruit and mentor volunteer attorneys, organizes clinics to support asylum seekers and immigrants, and maintains a diverse caseload of immigration matters. She is fluent in French and English, with conversational proficiency in Urdu and Spanish, enabling her to bridge communication gaps for diverse clients. And just a quick note about us. The Commission on Immigration directs the American Bar Association's efforts to ensure fair treatment and full due process rights for immigrants, asylum seekers, and refugees within the United States. And we encourage you to become a member of the ABA if you aren't already. There are many benefits, including joining with like-minded professionals to build your professional network, and benefits also include CLE programming and discounts on national brands and services. Visit americanbar.org/membership to become an ABA member today. And our agenda for today. Before we jump into the agenda, we just want to recognize that there have been a lot of changes this week between executive orders, policy memos, press releases, all of which we have read, but some of which we have not yet seen implemented. So we'll be talking directly about some of them and alluding to others, but while I'm sure it is very top of mind for folks, a lot of these we haven't seen in action yet. So unfortunately, the answer to some questions will just be, we don't know yet, or the answer is unclear. So today we will get started with a background on asylum law, and then jump into asylum versus similar protections, and then give some examples of thorny issues, and then barriers to asylum. And then we will finish with pro bono opportunities before opening it up for question and answer. And I will pass it over to Amelia.
Thank you, Emily. So great to be here today. If you don't mind switching to the next slide, please. Thank you. So really excited to be here today, and I want to thank all of you for your participation today. This is a critically important issue, especially these days. You hear about it more in the news. So we want to just talk about what is asylum for people who are new to the topic, and hopefully for those of you who are, have worked in this area, hopefully give you some tips on sort of moving forward with all the volatile political landscape. So before we go into asylum, I want to talk about some big picture ideas before we, get into the nuts and bolts of asylum. So first of all, if you're new to asylum and you're wondering what it is, you hear about it a lot. The most important thing to know about asylum is it is a critical life-saving protection for people who are fleeing persecution in their home countries and are trying to seek legal protection in a country of asylum. And it's important to remember that this protection is not new, it's not arbitrarily created, but rather, as Peggy's going to talk about shortly, modern U.S. asylum law is deeply rooted in international obligations that the U.S. voluntarily took on by acceding to the 1967 protocol related to the status of refugees. And the concept of asylum is much older than that. So this is deeply rooted protection. So when we're thinking about asylum law and policy with that kind of context, we're not just thinking about domestic law. So we're thinking about these broader international obligations as well. So we're talking about what asylum is when you're seeing how it's been implemented in policies and practices. I want you to think about how these policies and practices line up with those international obligations. And as we're going to talk about at the end, asylum is often unattainable. They don't often meet up. The system does not meet these international obligations, even for people who might have strong claims to relief. We're going to talk about significant barriers that asylum seekers might face. Asylum law, for one, is notoriously complex. What we talk about today is going to be just a simple overview in a very short period of time. When Margaret and I were planning for this presentation, we were talking about, we could talk about asylum for a whole semester when we're teaching. So in practice, it's very complex. We're going to oversimplify it just for the purpose of this presentation, but it's also volatile. As you've seen with the flurry of executive orders, we will allude to some today. It's a volatile political landscape, even for practitioners. And so imagine if you're proceeding without counsel and trying to face not only the complexity of asylum law, but also its volatility. For practitioners who are interested in keeping up with changes in asylum law or changes that the administration is proposing, this link on this website is a good way to keep track of that. And it's important here to stress also, as I just mentioned, many people who are facing this system do so without counsel. There's no government provided counsel for asylum seekers in the vast majority of cases. And so many people have to navigate this process alone. And this can be complicated by other significant barriers that I'll address later. And having counsel can make all the difference. So if you are interested in participating, our colleague Ambreen is going to talk about some opportunities where you can get involved. Next slide, please. Thank you. So just to give a really quick overview of what asylum is, if you're new to this. So asylum, with some exceptions, is the only requirement to apply is to be a non-citizen physically present in the U.S. Under INA 208, INA 208 says generally that's whether or not the person arrived at a designated port of arrival and irrespective of the person's status. As you will see, there are some executive actions that have attempted to change that application process, but that's a general provision in INA 208. Asylum can be used as a defense to removal if a person is in removal or what we used to call deportation proceedings, or it can be also an affirmative protection for somebody who's not in proceedings, and Margaret will discuss what those procedures look like. But at the very heart, a person applying for asylum needs to demonstrate that they meet the definition of a refugee. So the big overview of what a refugee is, again, this is an oversimplified version, but the most important elements, the critical elements, are to show that the person has suffered past persecution or has a well-founded fear of future persecution. And you might be thinking, well, what is persecution? It's a definition that courts have struggled with to sort of define, but generally it's a threat to a person's life or freedom, or the infliction of suffering or harm upon those who differ in a way regarded as offensive or sort of commonly accepted general definitions. This can be very fact specific though, and the kind of nuanced definition can vary from circuit to circuit. We usually think of this as serious physical harm, but it doesn't have to be. So it can be also emotional damage or emotional harm, psychological harm, or in some cases, severe discrimination. And as I mentioned, you can either show this element by showing past persecution, which creates a rebuttable presumption of a future persecution, or you can independently show a well-founded fear of future persecution. It's not necessary that you suffered past persecution. When you're thinking about this, you're thinking about both subjective and objective components. So not only is the person fear, but is it objectively reasonable? And you prove this with credible, direct, and specific evidence that supports a reasonable fear. But it's important for asylum that it doesn't have to be a really high chance or probability that this persecution could happen. The Supreme Court in INS versus Cardozo-Fonseca said it may be as low as a 10% chance that this could occur. So that's important to remember. I also want to talk about nexus. So not only is it critical to demonstrate persecution, but also that the persecution is tied to a protected ground from the Refugee Convention that Margaret's going to discuss in more detail. So these listed here, race, religion, nationality, political opinion, membership in a particular social group are the protected grounds. And you have to show, if you're applying for asylum, that the persecution is at least one central reason for that persecution. And that's important because it doesn't have to be the only reason. There can be mixed motives from the persecutor, but it should be at least one central reason. It's important also to remember that people might have more than one ground for which they are facing this persecution. So it's a strategic choice when you're thinking about which grounds to advance. But you want to make sure that if you're advancing different grounds, you argue them fully, that you don't just mention them, that if you're going to raise them, that you argue them fully. It's also important here to remember there can be imputed grounds. So the person doesn't actually have to have a particular political opinion. It could be that their persecutor is imputing it. And so that's important to remember as well. And finally, the government has the persecutor is either the government or an actor the government is unable or unwilling to control. So you can demonstrate that the government's unable or unwilling to control a private actor through the applicant's testimony, witnesses, country conditions evidence, news reports, and expert testimony. And it's important to remember, you'll see the practice in some courts where some immigration judges will say, you can't prove that the government was unable or willing if you didn't report the particular harm. But in most circuits, you don't have to have reported if you have evidence that reporting would have been futile or dangerous. So see matter of SA, a BIA opinion, or matter of CGT. There's some other considerations that we're going to talk about in a minute. So this is not the only thing to think about, but I'm going to pass it to Margaret to talk about some more background before we get to some more of the nuts and bolts. Thank you.
Good afternoon if you're on the East Coast, and hello if you're anyplace else where it was still morning. First of all, I want to say thank you to the Commission on Immigration for this opportunity to share some ideas with you on asylum law, and thank you so much to my co-presenters, Emily, Amelia, and Ambreen. It's been just it's been a pleasure preparing and working with you. I'd like to take a few minutes, first of all, to talk about sources of law for asylum. And, you know, this might sound like a boring topic, but it is actually fascinating. And since we're talking about hot topics, I'm going to highlight for you what there is in the sources of law that might be contributing to the hot topics that we're dealing with, especially in the current environment. So as Amelia said, the roots of asylum law are in international law. Yes, thank you for the slide. The mother of all asylum law is 1951 United Nations Convention, the convention relating to the status of refugees. It is amazing, as in retrospect, this was a very humble convention. It was 1951, and it was post-World War II. And the convention itself was intended only for Europeans who had suffered in conjunction with World War II and the Holocaust. And it was only meant to have a lifespan of 2 years. And yet from 1951 to now, we find ourselves in 2025, the bones of the Refugee Convention are still controlling law. in those bones, if we look at Articles 32 and 33 that Emily was kind enough to put up for us, we see problem areas that we may be encountering at the moment. So looking at Article 32, the contracting state shall not expel a refugee lawfully in their territory. The troubling language could be lawfully in their territory. We know that there is a lot of controversy with programs like Remain in Mexico, and these might be tied to lawfully in their territory. Are the asylum applicants waiting in Mexico lawfully in the territory of the United States? So here we see in this source of law already a source of a current problem. Moving to Article 33, and this Amelia did a wonderful job with this. We see in the first section, the first paragraph, that it's not enough for an individual to say, I can't return to my country because my life or freedom might be threatened. That threat has to be tied to one of 5 grounds. And as you can see, the 5 grounds are set out here. The ground that is the subject of most litigation is particular social group. So most of us, if we are asked for a definition of race or religion, we have a pretty quick response of what constitutes race. However, if you look at particular social group, that's a more difficult task to define. And indeed, from 1951 to 2025, we are still struggling with that definition. If I could switch to the next slide. And here we have the controlling domestic law, which is found in the Immigration and Nationality Act. And if you look at the left bottom definition of refugee, 101A42, 101 has all the definitions for the Immigration and Nationality Act. We see the definition of refugee, and it looks exactly like Article 33. So domestic law incorporates the international law, and asylum and withholding of removal have that same definition in it. There is one more immigration and nationality section I would like to bring to your attention, and that is on the next slide. That is INA 212F. 212F is not specifically asylum provision. It is, however, a provision which will or already has impacted asylum and many other dimensions of immigration law. 212F, as you can see when you read it on the screen, gives an enormous amount of power to the president. And the president, if he deems that a certain class of non-citizens are detrimental to the interests of the United States, he has the authority to issue a proclamation, which he has done. And if he deems it necessary, he can under 212F suspend the entry of all non-citizens or any class of non-citizens and or any other restriction. And if you've been following the proclamations, the executive orders, the executive actions, 212F is actually cited in addition to the US Constitution, Article 4, Section 4, which talks about invasions. Moving quickly, and we do have to go quickly, to procedure. The next slide, please. The mainstream procedures for, this is sort of the Cadillac version for seeking asylum, is for the non-citizen to either affirmatively or defensively fill out a written application, a form I-589, seeking asylum. And if he or she is in immigration court and the asylum application is denied, the non-citizen can appeal that denial to the Board of Immigration Appeals. And if the non-citizen needs to have that, wants to have that reviewed further, and so if it's denied, the non-citizen can file a petition for review in the federal courts of appeal. Notably, each of these adjudicators, whether administrative or judicial, are considered independent adjudicators. And that is supposed to be the mainstream way to seek and pursue asylum through adjudication. However, there is another procedure that is not on the slide that is becoming increasingly important. And that procedure is Attorney General certification. So we'll be talking about this more when we get to the thorny issues, but please keep in mind that there is a procedural vehicle whereby the Attorney General, who is political and not necessarily independent, can certify a case to himself. So if, for example, the Board of Immigration Appeals grants an asylum application, and this grant comes to the attention of the Attorney General, the Attorney General has the authority to certify that case to himself, reanalyze it, and vacate the Board of Immigration Appeals decision and come out with a different outcome. Also, another source of law or procedure, I guess, as we've seen this week, are executive orders and proclamations. Now, all of our presidents have issued executive orders in, I won't say all, but all of the recent presidents have issued executive orders in the area of immigration. But it appears that these executive orders are increasing in frequency. And of course, again, there is the tug between these independent adjudications and politically motivated orders. Finally, next slide, please. Here is a piece of the written asylum application, which if you take up Amelia's suggestion and take an asylum case, you will be assisting the applicant in filling out this application. And these two, it's a longer application, and the beginning is, name, address, that type of thing. But the guts of it is right here where you'll see it tracks both the Refugee Convention, it tracks the Immigration and Nationality Act definition of refugee and then asks for explanations. It is critical to do this application very carefully because along this proceeding that we just talked about very briefly, credibility is extraordinarily important, and it's important for all the details to line up both in substance and just putting down all in thoroughness. So if something is omitted, that also can be hard for the applicant to explain and hopefully prevail in his claim, because the standard is totality of the circumstances, and it's understood in a very broad way. That in a nutshell, in a very small nutshell, those are the sources of law and also the procedures in asylum law. And now I'm going to turn it back to my colleague Amelia to get more into the nuts and bolts of asylum withholding and CAT.
Thank you so much, Margaret. Next slide, please. Thank you. So we've talked about asylum, and thank you, Margaret, for that fantastic overview of the procedure and sources of law. Now I'm going to dig into some of the problems in addition to the definition or the elements for asylum, some other places where, you know, a person might not be eligible for asylum despite meeting those elements, and what other opportunities or protections might be available. So we already talked about the elements for asylum, and the likelihood of persecution being this well-founded fear standard, which is about 10%. As Margaret mentioned, asylum can be both affirmative and defensive, but it's important to know that ultimately it is discretionary. And so we'll talk about where some of the problems might be in just a second. But before that, one of the common problems for asylum applicants is that generally a person has to file for asylum within 1 year of their entry. So you'll hear a lot about this 1-year filing deadline. There are some limited exceptions. For example, if the person has changed personal circumstances or changed country conditions or exceptional circumstances that prevented them from applying. But if they don't meet those limited exceptions, they may have lost a chance to qualify for asylum. Other important thing to remember about asylum, and this is a place where we could see some changes in the administration and how executive actions could impact eligibility, are bars. So there are several types of bars that a person might face that could prohibit their application or ultimate eligibility for asylum. So some of those are procedural, or what I kind of grouped together as procedural. So not meeting the 1-year filing deadline, if you've had a previous asylum application denied. One of the sort of areas where we saw movement in this area under the last Trump administration is these safe third countries agreements. So if a person could be removed to a safe third country with which or with whom the U.S. had an agreement, they could be barred from then getting protection in the U.S. And firm resettlement. So if a person was firmly resettled in another country before seeking protection in the United States, that can be a bar in some circumstances. There are also bars, for example, if the person has been a persecutor, him or herself, and certain criminal bars, say for particularly serious crimes that the U.S. believes makes them a danger to the U.S., or serious non-political crimes outside the U.S. And there are also some terrorism-related grounds where we have seen movement in the past kind of expanding the definition of what those mean, or a broader application of those grounds. And so that could be an area where we see some changes as well. So what happens if you're representing somebody and they're not eligible for asylum based on these reasons? You would also want to consider generally, even if a person is eligible for asylum, you might want to think about withholding of removal in addition, so a person can apply for both. And that could be, for example, if the adjudicator finds that the person is barred for asylum, maybe they are still eligible for withholding of removal or protection under the Convention Against Torture. For these, it's important to mention for withholding and CAT, both CAT withholding and CAT deferral. So there are 2 remedies under the Convention Against Torture, which is another international protection. These are only defensive, unlike asylum. They don't have an affirmative option. So that's important to remember. They also have higher burdens of proof. So it's more likely than not that you would suffer the harm either under withholding of removal or CAT. So withholding of removal is very similar in terms of the elements the person needs to prove, very similar to asylum. So you're still looking at persecution or harm to a person's life and freedom. And you're also looking at this nexus, so the connection between the harm to one of these protected grounds. The Convention Against Torture, on the other hand, is totally separate. So you're not looking at a nexus, you're not looking at persecution, instead you're looking at torture. So it's the intentional infliction of severe pain, torture, by the government or by someone acting with government acquiescence. So the analysis is different. This is really important because, as Margaret mentioned, there might be more vulnerabilities to asylum, particularly particular social groups. And so if your client might be eligible for CAT relief, while it's not as strong, it could be an alternate if the person is not able to demonstrate to the adjudicator persecution or nexus. The nexus is really where CAT can be helpful, where the person doesn't have nexus, because often this torture would rise to the level of persecution. So it's often where the person lacks that nexus, but would still suffer this intentional infliction of severe pain. And that government acquiescence, or by the government or with government acquiescence, is also important to remember for CAT cases. Now, as I mentioned, these are both more likely than not. So withholding and CAT are both more likely than not. So it's a much higher standard the person has to meet. They are defensive only. But what's important is these are not discretionary, unlike asylum. This is where some of these treaty protections kick in, the non-refoulement, the prohibition on returning certain people who would face these harms. There's no filing deadline, so that can be an important consideration for these protections as well. And while bars exist to the withholding remedies, so withholding of removal and CAT withholding, they do not exist for CAT deferral. So you could have people who would otherwise be barred from relief just because of a particular history, but could still receive deferral under the Convention Against Torture. Another important thing to remember is the ultimate protection. So asylum has an ultimate pathway to permanent residence and U.S. citizenship. Withholding is it's a far more precarious remedy, because you actually get a removal order and you don't have a pathway to U.S. citizenship. Deferral is even less of a strong protection. It's easier for the government to terminate that protection. But when no other options exist, it's really important. So I just want to stress, do not forget about the Convention Against Torture. Many attorneys will think, so carefully about asylum and withholding that they often forget about CAT relief. But if it applies to your client, it could be a lifesaver. So I will pass it back to Peggy to continue talking about, I think you're talking about thorny issues in asylum law. So we're going to dig into some of these hot topics we're seeing today. Thank you.
Hello, I'm back again, and I'm going to talk to you about some thorny issues now. Asylum law is full of thorny issues. I'm going to just focus on a small part of just one thorn or one group of thorns. So next slide, please. As we mentioned before, a particular social group is the place where there's the most litigation. And the reason for that is what does particular social group mean? And where is it defined? Well, it is not defined in the statute. It is not defined in the convention. In terms of the case law, there are a lot of analytical frameworks, a lot of descriptions, but no definition either. So in U.S. law, there have been a couple of analytical frameworks that have evolved over the years. The most basic one is that there is a two-step. These are not sequential necessarily. There's a two-step framework. First, is the proposed social group, the group that the applicant identifies, is it cognizable? And the second one is there a nexus? Is there a connection between the claimed facts and the proposed particular social group? Let's take the easier one first, which is number 2, nexus. Nexus, that's part of every ground. Cognizability, on the other hand, is this group cognizable, this group that we have no definition for? That's a pretty hard standard to meet. Next slide, please. So from 1985 forward, the standard was immutability. What that means is the members of the group, do they share a characteristic that is unchangeable? Do they share a characteristic that either cannot be changed, or that is so fundamental that the members of the group should not be required to change it? This was the only standard for many years. And then, 2012 or so, the US law added more standards. There was quite a bit of discontent on the part of the Court of Appeals judges, because they didn't know really what particular social group meant. They didn't know what cognizability meant. They didn't know what immutability meant. I mean, they had ideas, but there was no uniform guideline really they complained about. So next slide, please. The board issued a number of precedential decisions and ultimately came out with matter of MEVG, which set out three standards to show cognizability, to show particular social group. That the immutability standard was retained, and the board added particularity and social distinction, more amorphous terms. Particularity in isolation means, is there a clear line? Is there a clear benchmark? Who is in the group and who is not in the group? Social distinction means what the society where this persecution is from which this persecution is feared. Does the society view the identified group as distinct? At this point, an asylum applicant who wants to pursue a particular social group claim needs to show immutability, particularity, and social distinction. Unless this is tied to an example, it probably doesn't mean much at all. So let's tie it to a particular example. And but can we skip to the next slide and look at matter of AB? Matter of AB deals with a case where a woman was seeking asylum, and the harm that she feared was and had experienced was severe domestic abuse. Now, in setting out the 5 grounds for asylum, and this is back in 1951, again in 1967 with the protocol, and then in 1980 in the US Refugee Act. There are 5 grounds. One of the grounds that is missing is gender. There is no gender ground. So someone who is seeking asylum based on gender-related harm has to, usually seeks relief under the particular social group ground. And as we just went through, there are the three standards that this woman, this asylum applicant needs to meet. So let's try to combine everything and follow the chronology of A, B, and C, how the hotspots of a particular social group, the hotspot of the omission of gender in the grounds, and the authority of the Attorney General to certify a case to himself rather than just leaving it to the independent adjudicators. How this all can come into a perfect storm and create a number of hotspots for us to be careful of as we go forward. Matter of AB was first heard by an immigration judge. The immigration judge denied Miss AB's asylum application on various grounds, including that she did not show that the particular social group of women who suffered abuse in marriage and couldn't leave the marriage. He didn't find that, the immigration judge didn't find that proposed particular social group cognizable. Miss AB then appealed her case to the Board of Immigration Appeals. The Board of Immigration Appeals disagreed with the immigration judge and granted her application for asylum. At that point in 2018, we had Attorney General Sessions under the Trump administration who used his authority to certify the case to himself, and he vacated the board's decision, overruling ARCG, which was a board decision that the board had relied on. And so at that point, Miss AB's asylum application was denied. Fast forward to 2021, Attorney General Garland certified the case to himself, and he vacated the decision made under Attorney General Sessions. And so here we have the perfect storm of how the political influence interferes with the independent adjudicators. We have the problem of not having gender as one of the grounds, we should have 6 grounds instead of 5, some would argue. We have the problem of particular social group and cognizability being such amorphous terms. And so here you have a package of thorny issues in immigration law and things, the types of things we could be facing in the coming years. And with that, I'm going to turn the time over back to my colleague, Amelia.
Thank you so much, Margaret. So now I'm going to talk about, so you've heard about the complexities of asylum law and how rapidly it can change, or interpretations of asylum law can change. So I want to talk about some barriers that people seeking asylum face. So imagine how difficult this is, not only for practitioners to keep tabs on all of these changes and navigate these challenges, but imagine if you're facing this as somebody who just entered the country, may be in detention, may not speak English or read English, or having to navigate through these forms, knowing how to navigate through these changes. So I'm going to talk briefly about some barriers before passing it to our colleague Ambreen to talk about some opportunities to support people in this situation. So these are some of the many barriers that asylum seekers face. I mentioned, first of all, the lack of legal representation in the vast majority of cases. Many people who are seeking asylum have suffered significant trauma. and could be detained through this process without appropriate resources, either inside detention or outside detention, for the trauma that they suffered, this insufficient support for that. These barriers often have greater impacts on people from marginalized communities. So just to give you an example, before I came to Arkansas, I was in Mississippi, where the massive ice raids happened in 2019. And many of the people impacted are indigenous Guatemalans and spoke their best languages are indigenous Guatemalan languages. Many people, hundreds of people went to detention and did not have adequate interpretation supports, even in court. Many people had their cases reset multiple times because the court could not get interpretation services that the person could understand. And so these impacts can be greater, like I said, on people from marginalized communities. Also, a volatile legal landscape that we've talked about as you see these executive orders, kind of how asylum law is applied is confusing and volatile. And also various misinterpretations and misapplications of substantive law. I mean, I've had cases, I used to work on asylum appeals, in cases, for example, where a judge said, you know, if you can't prove past persecution, you have no ability to get asylum, where the person had a well-founded fear of future persecution. So, you know, you can have circumstances, especially with growing political pressures, where you get just really bad decisions. And if a person is pro se, their kind of knowledge about how to appeal these decisions and challenge these decisions, you know, their resources, they might be stuck in detention, and so their possibilities of applying and challenging decisions may be less. And so all of these sort of combine to create, you know, in some cases, insurmountable barriers, even for people who have really strong claims. Next slide, please. So just to give you, you know, again, we already talked about some of these things, but imagine navigating this, representing yourself. Again, the vast majority of people do not have access to legal representation. I'm going to show you some statistics in a minute and what that means. And as I mentioned with the appeals, that means limited accountability also for the system, right? Because you have fewer people with representation and the means and resources to appeal bad decisions. Next slide, please. So just to give you a visual of what this looks like, we see from the Congressional Research Service growing numbers and percentages of unrepresented people. And as more and more people kind of talk of greater, you know, arrests and people put into deportation or removal proceedings, I should say, you see growing numbers of people in proceedings, and among those numbers, greater percentages of people who are unrepresented, who are facing these proceedings alone. And with greater talk of increasing detention, these are more and more people who are detention, often in rural places away from sort of large scale legal resources, like numbers of legal resources. And then you see what a difference it makes. So these are relief grants and denials by representation status in the second figure. And you see what a difference representation can make in helping somebody access this relief and actually get this protection. So I'm going to turn it over now to our colleague Ambreen to talk about in IGP's experience, what these barriers look like and how you can get involved. Thank you. Oh, sorry, one more thing. Yeah, we can just skip to give Ambreen some time. Thank you.
Thanks so much, Amelia. I really appreciate you setting the stage for how individuals can get involved. Next slide, please. So this is what detention looks like. Amelia alluded to what we anticipate being more people, more individuals placed in detention and immigration detention. This is the Otay Mesa Detention Center. It's located about 6 miles north of the Tijuana border. And as these images depict, it's very much a jail. It houses, as well as people in immigration detention, it houses people in marshal's custody. Upon entering, you'll notice there's barbed wire, double fencing. It's very high security. Visitors have to pass through rigorous checkpoints, removing their shoes, walking through metal detectors, having bags scanned. And in this facility, there's no internet access. There's no access to easy communication lines. Currently, the facility that we service at IJP, the Otay Mesa Detention Center, has about 1,400 individuals in ICE custody. And as Amelia mentioned, the rates of representation for these individuals is very low. We've relied heavily on our legal orientations program, which provides pro se services to orient these individuals on what their legal rights might be, what remedies they might have in court, and also kind of act as an additional monitor as to what's happening in the detention center, and also provide us in-house referrals for cases that we can take on here at the ABA Immigration Justice Project. These programs have served as a legal lifeline for the individuals in detention. And what we're seeing just this week is a stop work order that's a result of Trump administration executive policies, where now these programs cannot deliver the essential services that they have been delivering, whether it's help with pro se 589 assistance, group orientation workshops that provide information on how people can get out of detention through bonds and parole, et cetera. The stop work order has really, it's impossible to describe how heartbreaking it is to know that there's a whole facility and many facilities across the country that now there are individuals in there, massive populations of individuals that will be growing that don't understand and don't have access to the information on how to represent themselves in court, and sometimes even the information on how to reach a representative or get in touch with the first contact that would lead them to representation. So I say this because right now, what we need more than ever from individuals who might be interested in giving their time is representation. We really need attorneys and accredited reps to take on asylum cases. We know that it's very difficult to gather information from the detention center about your case. So gathering evidence is very difficult when you are detained and have little access to things like WhatsApp and so on. It's hard enough for attorneys to reach their clients. It's even harder for people who are pro se to reach their family members outside of the detention center in their home countries that might be able to provide the resources and the evidence and documentation that they would need to support their claims. So in that sense, attorneys and representatives make a huge difference in the success of an individual's case. So that's for our detention center, for the Otay Mesa Detention Center, and for the downtown San Diego Immigration Court, where we service, we're looking for California-based attorneys to provide that direct representation, attorneys who are willing to have client contact and meet with clients. We do have other opportunities for direct representation. We are looking for attorneys to assist with appeals. As Amelia mentioned, when people are pro se, it is a high burden, and it's very difficult to win a case. And so we have a lot of individuals who have been pro se at the first instance who now have, perhaps a better shot to win their case, or at least to have their case remanded. And so remote attorneys can assist with Board of Immigration appeals. This involves briefing a case. It involves, there's little client contact, and it can be done remotely, but you can still deliver a significant impact. For non-lawyers, we also have, we look for interpretation. If you speak a second language, it can be incredibly important to, incredibly useful to have your services to help translate documents, to help facilitate contact between the attorney and the client. So if you speak a language, Russian, Mandarin, Haitian Creole, Spanish, please consider filling out the interest form by accessing the QR code here. We also have limited scope volunteer opportunities for both non-lawyers and lawyers. For lawyers, we have the federal free legal answers. It's a clinic where volunteers can answer basic immigration questions online. Here at IJP, we've been facilitating work permit clinics. And then finally, an opportunity that can be done remotely for both lawyers and non-lawyers is country conditions research. Again, if you speak a second language, this can be very helpful. Country conditions research is basically gathering information and reports about conditions in an asylum seeker's home country. And this information can be pivotal by supplementing the record and by by contextualizing a person's asylum application with reports, news reports, UN reports, etc., that can help the adjudicator really can help the adjudicator have a good perspective of what the asylum seeker's claim is. And it can be pivotal for the success of the case, and that can be done remotely by lawyers and non-lawyers. Your help really matters, especially at this time when we're seeing so much volatility and so much of our own programming and funded programming being cut. We are going to rely very heavily on volunteers to help us make sure that due process is preserved as much as possible. And with that, I leave it to Emily to facilitate question and answers.
Thank you, everyone. We have a couple minutes for questions if folks have any. Feel free to enter it into the Q&A section. All right. Well, I will buy you another minute, but thank you to our fabulous panelists today. I found the information very informative, and you will be receiving a copy of the slides and some additional materials when for everyone who registered. You will be getting that, and you'll be getting links to the recording. Thank you so much for your time and attention today. And I apologize that we are already at time.
Hi, Emily. It seems we have one question that's probably Amelia or I can answer. And it says, how do we overcome the lack of nexus most judges seem to argue? Amelia, do you want to come on too and answer this also?
Absolutely. And I apologize, I have to leave shortly. But that's a really good question. So one of the possibilities is to think about all the possible grounds it could be, and sort of really dig deeply into those with your client. And that could take, multiple client interviews, I've found, and really sort of digging into the country conditions research on why these things are happening. Find, examples of similarly situated people. I really found that sort of building up that evidence is particularly helpful. And also consider CAT, right? If CAT applies, CAT can be a helpful alternative where nexus is going to be a real problem.
Yes, and I agree. If nexus is a problem, then CAT is the answer, and certainly research that is focused is very important. It's sometimes unproductive to just file like a whole country condition report. It's much more helpful to point the adjudicators to the exact part of the country condition report that applies, or the exact anything, rather than filing by the pound.
Absolutely. And experts can be really helpful on that point as well.
That is, I agree with that too. So I don't see any other substantive questions. Are there?
Thank you all again so much, and thank you to the attendees for your time and attention today. And together we continue the fight. Thank you, everyone.
Thank you. Bye.
Thanks, everyone. Bye.
Thank you.